you short. But my name is Helen Durbin, and so I'm going to take you for today. So what I'll do, if you don't mind, is I'll just take a roll to check who's here and who's not, and then I'll just want to. We'll just spend a couple of minutes just finding out your background, because I just want to know how much experience people have got, because this is sort of today is sort of the basic course, and if some of you are lawyers, this will be very familiar to you already. Okay, so Barbara.
Yes.
Hi, Barbara. Chris?
Yes.
Hi, Chris. Christine?
Yes.
Christopher Peter? I've got. No. Melissa? Katia? Stuart?
Yes.
Regan? Jason? Sarah?
Yes.
Venetia?
Yes.
Carol? Carol here. Oh, that's it?
Okay. Well, I'm Chris. I'm probably Christopher Peter.
Oh, you're... Oh, okay, yeah. Okie doke, just as well. I don't know what here.
Another Chris.
Okay, so have we got lawyers here already? Oh, this is going to be really familiar to you. I'm going to take you back to law school days. It might not be pleasant.
So I'll try not to ask too many questions since I'm the only lawyer.
You're a non-lawyer, but are
I'm
you?
not a lawyer.
Yeah, are you practicing in the area, working in the area?
So I'm an authorised financial advisor.
Oh, okay.
And I currently run Paraplanners, who are providing advice to trusts.
Yep.
And I also look after the quality assurance team that check all the files to make sure that we're meeting all our obligations. So
Yeah.
we ask lots of questions on trusts, so that's really well.
Okay. All right. Okay. So I'm just going to go through all of you lawyers. If this, I don't mind if this is all really familiar to you. You don't have to stay all day. Yeah.
I'm going to have to level one anyway.
Yeah. Okay. All right. Right. So let's get started. What I just wanted to do to start with. So I've got something weird on my screen. It was just go through a little bit about the history of trusts and equity, and then we're just going to go through the main types of trusts, how we put trust deeds together, you know, those basic sort of things. So we'll start in history. You may remember this, and I'm just going to go back actually before 1066 and the Battle of Hastings just to start. And what I'm going to talk to you about is the two systems of law that we have in English law, which, you know, under English law, which we inherited as a colony. So there are two sort of systems of law that have operated throughout most of English history, which is obviously the common law set of rules and equitable set of rules. So I'm just going to remind you about why we've got lawyers, why we've got equity. So if we go back, sort of right back to the Greeks, and really, you know, Aristotle and Plato and Socrates, it was sort of acknowledged in sort of philosophy at the time, in terms of rule making, that you could never possibly make a rule that would work properly 100% of the time. And the example that was given by the Greeks was that if you had a rule that said it is a crime to raise your hand if you hold anything metal, then if I put my hand up because I'm wearing a ring, I'd be liable, you know, guilty of an offence. So in rulemaking, what tended to happen was that systems came into play that overrode the normal rulemaking system, and basically a mechanism to alter the rules and the result if the rule didn't work properly. Yeah. And it came from the notion came from a Greek word, epieikeia, which we would term equity. So this idea that you needed in your legal system a little mechanism to tweak the rules where they didn't work goes back to the Greeks. Actually, it probably goes back earlier than that. There is some suggestion that it goes back to old Jewish law. It was adopted by the Romans, that same sort of notion. So if you look at some of them, you know, Justinian, for example, who was, I think, an emperor towards the end of the Roman Empire in about the 500s, he had a book of laws put together by a number of, you know, lawyers and scholars. And if you look in that, you'll see a reference to this idea that you need equity. So you'll have a set of rules, but you need equity alongside it to adjust the rules. And in Justinian, in the text, it will say the dominant set of rules should be equity over rules. So we, in our legal system, or the English legal system, adopted that same sort of thing sort of through the centuries. It happened over a sort of a period of time, and the reason it came into English law was because a lot of the people who dominated the legal system at the time were ecclesiastics, so priests, and their education was in canon law, church law, and because it was Catholic, it was the Holy Roman Empire, it's based in a lot of Roman law as well. Yeah. So we have, these two legal systems that have risen up and exist, and they still exist now. And in fact, a lot of people, a lot of people or academics believe that the reason, say, for example, that English law has become the dominant law of finance in the city is because of the benefits of equity. It was a particular type of metaphysical thinking that actually didn't exist in civil law jurisdictions, like, France and Germany. And that ability to think in that particular way has actually resulted in a dominance of English law as the law of finance, because it's flexible and conceptual and flexible, and not based on a code. Anyway, so if we look at what was happening in English history and why we got trusts, before 1066, England was just basically a group of sort of counties or different sort of kingdoms that were ruled over by various sorts of people. In 1066, you had the Battle of Hastings. William the Conqueror came over and conquered basically what is Britain, shot Harold Godwinson in the eye and took over. And he did what all good, I suppose, people who win wars do. He set about dominating the population, and he did that. One of the ways he did it was by putting in place a good administration. So his idea was that he'd dominated this country that had all sorts of little populations with separate rulers and separate courts in each, and often different rules that applied in each place to the regulation of society. So he set about creating a cohesive system and a common law. So one set of rules that would be common to everybody who lived in the country. Now, what I've said to you is that with any legal system, what you need is your basic rules, like contract law, tort law, and over that you need a mechanism to alter the rules where they don't work properly. When law, sort of law, modern law as we know it, started to be put in place after 1066, they didn't actually have a separate equitable jurisdiction because everything was very small. And the judges had a lot of flexibility in what they could do. So initially it was sort of not really necessary, but as time went on and population increased and life got more complicated, problems developed in the common law system. Now the common law operated, as I said, as one body of rules that operated for everybody. To start off, there was only one court, the King's Court, so you'd go to the King for all your rules, most of them. And eventually, as it became more complicated, you got your three jurisdictions, which have existed, certainly, King's Bench, now Queen's Bench still exists, and Exchequer and Common Pleas are probably the equivalent, well, to some extent, the equivalent of Chancery Division. And what basically happened is that injustices started to seep into the system. Some of them were from political causes. So in 1285, there was a battle really between the king and some barons. It was basically about control. There had been what were called baronial courts, so courts where barons were landowners. They had had some rights to dictate certain rules to people who lived on their land, and they saw the legal system as taking away some of their rights. And there's a lot of other stuff going on as well. So they fought the king, and they didn't like what was happening with the courts. They thought they were becoming too powerful. So an agreement was entered into, was put into statutory form called the Provisions of Oxford, and that limited the ability of the courts to operate. So before that, before 1285, if you had a legal problem, what you would do is you would go along to the courts. You'd go along to the office of the Chancellor, which is like the Prime Minister's office, and most people didn't write, so there would be clerks in that office who would actually write up your writs for you, and your statement of claim. and they were very flexible. One of the things that the barons resented was this ability to have open justice for people and to have any sort of writ written. So one of the things that you'll find in the provisions of Oxford is a restriction on the types of writs that the courts could write. So that meant that as a inhabitant or, probably a peasant, or if you had a legal problem that wasn't covered by one of the writs, there was nothing you could do about it because you weren't allowed to sue because of this agreement between the barons and the kings. So various sort of injustices came in. One of them was the rigidity with pleading. If there wasn't a form of writ or a statement, it's like a cause of action, you were basically, there was nothing you could do. The second thing was that the common law became sort of bound by rules of procedure that often actually worked in an unjust way. And the typical example we'd give of that is the rules in relation to bonds. Under that legal, at that time, if you were lending money, your same as today really, but your loan agreement would be put down in a document called a bond, and you'd sign it, or seal it actually. So you'd say, I, AB, owe, I don't know, £10 to CD, and then seal it. Now, that document, that bond, was incontrovertible evidence that that debt was owed. So what you'd normally do as a debtor on repaying a debt was get the bond back. Because if it was left with the lender, it remained incontrovertible evidence that that debt was owed. So you had cases, and if you were an ignorant debtor and didn't get it back, then the lender could demand repayment again from you. So, and it's just a silly rule, but it was in place, and obviously it operated unfairly. And the third problem with the system, the common law system, was that it had very limited remedies. And that's true now, today. If you look at the common law, there are really only two remedies. Well, there's one main remedy that we have, and that is damages. So that, there was another one at the time called novel decision, which was an ability to basically have somebody excluded from your land. And often we know that the remedy of damages just doesn't work or doesn't create a just result. So an example of that would be defamation. So if you have somebody like, happens all the time in England, you get one of the tabloids ringing you up, normally less than 12 hours before a print run, and saying, but we've been told the story about you, we're going to print it in the morning, be coming out in the morning papers at 6 o'clock. If you only had to rely on the common law, there would be nothing you could do. You'd have to wait for the story to be printed, your reputation tarnished, and then you could sue for damages. But the damage is already done, and money, repayment of money often would not be a remedy for a destroyed reputation. So what happened then was, with limited remedies and all these problems, was that people began to appeal to the king directly when there was an unfair result. They appealed to the king because the king was designated by God. He was, I think the Queen's, that she would now would accept that the same thing's in place. She's been put in place by God. Because there began to be a lot of appeals because the court system wasn't actually working terribly well. Then there was a delegation of power down to the Lord Chancellor, who, as I say, was like the Prime Minister. The Lord Chancellor operated the Chancery, where people had originally gone to have writs written for them. And so the Lord Chancellor began to deal with all the problems that came in. And because the Lord Chancellor and those people in that sort of level of society had a different type of education, being ecclesiastical, it was more classical and canon law and Roman law. They brought in basically a different type of decision making. So this common law courts would, although in the early days there was a mix, they tended, as time went on, not to have the same sort of educational source as people in Chancery. So the Lord Chancellor basically would make decisions based on a conscience and good faith. And that's where this idea of good faith basically came into our legal system. And because there were so many, of these types of claims over time, a separate court evolved, and that's the Court of Chancery, which still exists now. In fact, and I just read the other day that they're changing it. So after all this time, 700 years, the English are getting rid of the Chancery Court and they're going to have the business and property courts. So it's time to update. Why is that all relevant to trusts? Because certain practices evolved over time through, basically what was happening in people's lives, which meant that so they started to deal with property in a particular way, which was not protected by the common law. So the classic example of why trusts were created is the example of knights going off to the Crusades. So what would happen is that a knight would have certain rights over land and have people serfs living on the land and paying dues or feudal dues, and mostly they protected their land by living on it. And if they weren't there to protect it, so physically often they needed to protect it, fight people off it, and if they're going off to the Crusades and might be gone for 2 or 3 years, the practice evolved where a knight would ask somebody they trusted, a friend, to take legal title, so that have the deeds over the land, hold it, but not use the land for the friend's own purposes, but to use the land to hold it, protect it for the knight's dependents, wife and child, or children, or family. So under the, and there are another, I've put the other example there, Franciscan friars, they weren't allowed to hold property, so they would transfer land into somebody else's, give them somebody else the legal title who wasn't a friar, and then the friars could carry on living on the land. And there were examples of women in convents as well that were similar. So there became to be, just through practice of life, a number of ways in which the legal rules actually weren't fitted for what people were doing. So where a knight went away to the Crusades and came back, if their friend had taken control of the land and refused to hand it back, then at common law, there was nothing the knight could do, because the friend held the title deeds to the land, and under common law, that proved that they were the owner of it. So the knights would then go to the Lord Chancellor and say, I transferred this land, but only for protection of my dependents. And so the Chancery Court, and the Lord Chancellor and then the Chancery Courts began to recognise this form of use of property and protection of property. Okay? So if we look at what a trust is, when it first started off, a use, it was simply a conveyance of legal title to land, and normally it was land because that was the indicator of wealth for a very long part of our history. So conveyance of legal title land by one knight A to another B, but for the use of C, A's dependents. And the common law recognised the transfer of legal title, but what they did not recognise was that the land was going to be held not for the benefit of the legal title holder, but for other people, who we would call now beneficiaries. And that's still true today. The common law does not recognise trusts. Trusts are recognised only in equity, in the court's equitable jurisdiction. Okay. So if you're looking at some of the old cases to do with what we call trusts were originally called uses, you'd see that the trustee is the fio-fide uses, and the beneficiaries, the person the land was held to protect, so the dependents, would be called the setiki trust. And we use, at that time, and for quite a period of English history, French was used as the language of law. So you get some, these old phrases, and you still, some people, well, not very common now, but certainly up until about 20 years ago, a lot of people still used the term setiki trust to mean beneficiaries. So over time, that little device, that use, this idea that you could divide ownership and transfer legal title to somebody else, but for the benefit of another person, took hold, and it was useful in a number of ways. And very early on, it was seen as useful to avoid taxes. It was a method of avoiding taxes. So eventually, when Henry VIII, the crown coffers, were bare because he didn't have any money, he needed to raise more money, and he realised that using this device, this use or trust, was basically, he felt, robbing the, or him as the king of money. So he passed a statute abolishing the ability to do that, to transfer land to be held for the benefit of somebody else. So he abolished the use where it dealt with land. In fact, you see the similar things happening, not quite abolishing, but if you go back to Gordon Brown, trusts used to be used in England, not as readily as they are here, but they were certainly used by more wealthy people to avoid what we used to call death duties, but the English call inheritance tax. And Gordon Brown took steps, I don't know when he was, probably 6 years ago, to sort of limit that ability because it was robbing, say the revenue of tax revenue. Yes. Okay, now, in fact, what happened relatively shortly after, not that long after Henry VIII abolished uses, lawyers devised a way to get round the statute, and they did it just by reproducing twice the split in ownership. So they'd create a use, which was treated as being invalid, and then they'd create another use on top of that. And that wasn't covered technically by the statute. So it was a use upon a use, which is what we recognise now as a trust, sort of. So they did get round the legislation relatively quickly. And the tax situation changed in the United Kingdom with the Restoration. You know, they had the interregnum, but Charles II came back onto the throne. There was the coffers were fuller. So they didn't have so much there wasn't such a need to prevent this sort of activity in the natural population, and uses sort of came back into, or what we call trusts now, came back into play, and they became much more frequent again. So if we look at what a trust is, if you want a basic definition, I mean, there's a lot of descriptions of what trusts are, but at their most basic, what they are is a method of holding property, but by divided ownership. So I just want to talk to you a bit about ownership under English law. So if you look at the common law, our common law rules, the common law protects ownership of property the best. It protects ownership better than equity does, and we'll look later at why that's the case. But we have this notion of absolute ownership. And what that basically means is that if you say you own something, you have the right to possess it and use it however you want to do it. So there are certain benefits that go with ownership. You can sell something, you can destroy it, you can use it because creates benefits for you. You can basically do what you want with it. But also what comes with ownership are burdens. So if you own land, and some burdens actually you can't get past, you have to comply with them. So if you own land, a burden that comes with the legal ownership of land will be the obligation to pay rates, and you can't get out of that. So if you look at ownership, it's a combination of benefits and burdens that you hold. So basically what happens when you create a trust is that you are separating out the benefits of ownership from the burdens of ownership. And so you're dividing what is absolute ownership qualitatively, benefits and burdens, and you are giving the burdens of ownership to the legal title holder, the person who's recognised at common law as the owner, and that is the trustee. So they carry the burdens of ownership. And you're giving the benefits of ownership to the beneficiaries. And at its very most basic, if you have a trustee who's not a beneficiary, the trustee isn't allowed to enjoy the benefits of ownership. So we say a trust is advised to hold property by divided ownership. There are two people recognised as having rights of ownership in whatever the trust asset is. The trustee who's recognised at common law as the owner, but trumping that, equity recognises the beneficiaries as being the owners in equity, entitled to enjoy the asset. So there are all sorts of reasons why this, I mean, it's a very simple little device, the trust, but there are many reasons why it's been immensely useful to us. One obviously is in succession planning and the ability to, the ability sometimes to avoid forms of taxation. Two, if you're the owner of something, for succession planning, you can keep control. It's like a planned gift. If you can gift something absolutely, but then you lose all control on what happens to the asset. If you gift, you have a trust, and you can appoint a trustee, and there'll be some sort of control on it. And there's a saying that trusts are used to protect money from the family and to protect the family from the money. Yeah, so it's very legitimate ways to do it. Tax minimisation. Obviously, we use them a lot in New Zealand for asset protection, because they take, if you create a trust as a set law, and you are not one of the beneficiaries, or perhaps, then the asset no longer belongs to you. It's ring-fenced within a trust fund. So charitable purposes. I've got here taking advantage of social assistance, but that's being fixed. But the really big way that we use trusts now, and in fact the most significant use of trusts is in corporate finance. So they're used for all sorts of ways commercially. Just to give you an example, in bond issues, they're used to. We have rights between. You might have so you'd have a big debt issue, and often you'll put in place a special purpose vehicle to hold rights in relation to the lending, and investors will take interests through that special purpose vehicle, which can be a trust. They're used in securitisations, which are very, are a popular, an important form of corporate financing, because it's much cheaper to use use securitization as a method to get income into a company than its traditional forms like lending from a bank. So there are real efficiencies from using those sorts of structures. And again, often they'll be set up so you'll have a special purpose vehicle, which will be a trust, and investors will have the rights through the trust. They're used in loan subordinations where you have different, or syndications where you have a whole lot of banks that are lending money for one big project, where no one bank could take the whole risk of funding one particular development, like a tunnel or a bridge, or massively important things. If you've got a number of people investing, what you'll often do is have somebody who leads it and holds the rights on trust for all the others. So they're a very good mechanism for managing investments and transactions where you have a whole lot of people that will be putting money in, because what they do is they create an efficient way to manage the transaction. You'll have a small group of people who will make decisions, and there'll be trustees, so they'll be subject to fiduciary duties, which are elevated sort of duties that are recognised in equity, and that adds all sorts of benefits and protections for investors. So they're just a very efficient way. And
They never taken off in the States.
trusts?
Yeah.
Oh, they have.
Really?
Yes.
Really hear about this.
Well, yes. Oh, no, absolutely. Well, all of the states, apart from Louisiana, are English law.
Yeah, oh, yes, I know that.
Yeah. Yes, no. They've got them.
Like similar trusts to what we would.
Well, New
recognise.
Zealand's got a very peculiar. New Zealand, we're sort of completely dominated by trusts at the moment, aren't we? It's sort of a fashion, and there've been reasons why, we want to do it. So in corporate fundraising, absolutely, they use them, and so they are, and all sorts of other ways you can put assets into trust. We just tend not to look that much to American law. Actually,
Right, yeah.
We tend to, Australia, New Zealand, Canada, and England. We sort of those tend to be the types of place traditionally we've looked at. But there's a number of very good American, trust textbooks.
Right.
I think I've got a couple. We've got the library to buy a couple here, which you can use, if you want to. And the rules are often similar. Sometimes they're not.
Yeah.
And there's some interesting, because they diverted, after the War of Independence, 17 something or other, they sort of diverted off, and so there wasn't although they've got the fundamental rules are the same, there are some differences. Like we in New Zealand, and we'll look at this later, we have the rule in Saunders and Vautier that enables you to wind up a trust if you've got all your beneficiaries agreeing to it. They don't have that. They don't recognise that in the United.
Some states don't have a rule against perpetuity.
That's right. Yeah, it's the same sort of thing. Yeah. So widespread use of them. Oh, there we go. All sorts of things you can use them for. Oh yeah, obviously I mentioned pension funds, which is really the big use that we have now. And any sort of form of collective investment, as I say, where you've got a whole lot of people who are putting money in. It's just a very efficient way to sort things out.
And I read that a lot of the Commonwealth countries that don't have equity, that don't have trusts,
Yeah.
have recognised the benefit, and so they have codified trusts so that it's now part of their statutes.
Some have, yeah. There's an act, the Trust Recognition Act, and also the EU. Because the trusts are so useful commercially, the EU have put in. What they've done in their big financial directives is mimic English law, because of the protections that they provide for, if you're people investing or putting money into investment banks, you can either structure your investment as a contract so that you're just a debtor creditor, or in fact you can create a trust relationship. Yeah, and obviously there were a whole lot of problems with that, because that happened in the Lehman Brothers, with Lehman Brothers when they toppled. It was obviously under a trust, one of the things you need to do is segregate the asset, or you're supposed to segregate, and they hadn't done it. Anyway, so it's another story, but a lovely story about Lehman's. If we have time, I'll tell you. Yeah. Okay, so just going through our classifications of trusts. I've got all sorts of use them. They are as I say, throughout the whole legal system. In fact, there was a very famous French jurist who said of the trust that the trust is the guardian angel for the English, following the English from the cradle to the grave. I think that's probably true. So we have two sort of main types of trusts. We have express trusts. Now those are trusts that are deliberately set up by somebody. So a settlor or a testator will create a trust, and you can create them in at two different time periods, inter vivos or during your lifetime, which is obviously what we use all the time in New Zealand with our discretionary trusts, or in a will, a document, so a will trust. The next sort of demarcation you get are between charitable trusts and private trusts, and there are quite significant differences between these two. Charitable trusts can exist for a purpose, for the alleviation of poverty, or to advance education. So they can exist for a purpose. Private trusts, under English law or New Zealand law, cannot exist for a purpose. Now, that's, I think, likely to change. That's where we've got a particular system set up under English law where we say, well, a trust has got to exist for the benefit of beneficiaries, and trustees have got to act in the best interests of the beneficiaries. So we have those sort of global, sort of broadly worded principles, but it's very hard to know exactly what they mean, because often a trustee can't act in the best interests of certainly all the beneficiaries. So there's been some judicial writing. Lord Nichols is one who has said, well, maybe when we say that trustees have got to act for the benefit of beneficiaries, what we're really saying is that they've got to advance the purpose of the trust. So I think if we're looking at where things might go jurisprudentially, I don't know, maybe we're going to see some sort of movement between those two. That's the way they're set up. So it's just writing at the moment. Okay. So with private trusts, we then have actually a number. I haven't put them all in here, but the main divide, I would say, is between. Next would be between something called a fixed trust and between a bare trust. So I just want to describe what they are, basically. Where you have a fixed trust, what you have is a settlor dividing up ownership into benefits and burdens. But with the benefits, the settlor is saying specifically to the beneficiaries, you get this particular chunk. So they're told exactly what they get. But the trustee will have management obligations in relation to the assets. So they will have to actively be involved in looking after the asset and dealing with it for the benefit of the beneficiaries, and with heavy burdens on the trustee's shoulders. A bare trust is a trust where you separate out the benefits from the burdens. You appoint a trustee, but the trustee has no management duties. It's really used as a matter of convenience. Sometimes it's just an efficient way to hold an asset, but the beneficiary would normally, so what we say is the trustee holds the asset until they're told by the beneficiary to transfer it somewhere else. Yeah? So you as the trustee simply are a bit like a repository. There is an argument or a debate amongst academics as to whether trustees of bare trust, what sort of, if you say they don't have any management duties, what duties actually do they have on their shoulders? There is one suggestion, which I actually think is right, is that they would carry at least fiduciary duties, because clearly they can't steal the asset. Yeah. So there will be some duties that they owe, but they'll be minimised. Yeah. So the next big pool we have are these things called discretionary trusts that we use all the time. In New Zealand law, and they are trusts where we'll look at exactly how they're set up a bit later on, but they're basically a trust where a beneficiary can't point to any part of the trust fund and say that belongs in equity to me. What the beneficiaries have as they are, the pool of beneficiaries, entitled to receive assets if the trustees appoint the assets to them. So make a decision that they're going to distribute some of the trust assets to the beneficiaries. And then we have, all sorts, I haven't put them all in here, of commercial trusts. There are some fundamental differences between the way trusts are used in commerce and the way they're used domestically. The most significant difference is that they are often created by contract. So people will sit down and negotiate a contract, and within the contract or supplemental to it, sort of surrounding it, trust arrangements will be put in place. Now, the reason why, one of the reasons why equity is so important to commerce is because of its ability to divide up ownership qualitatively. Yeah? So in terms of what you can get. The common law can't do that. So if you look at what the common law can do, if you're the absolute owner of an asset at common law, so you're holding legal title to an asset, there's actually, and you want to divide it up, there's not that many things you can do. So you can lease it, you can lease it, you can give a license to occupy, yeah. But beyond a very few those very few things, the common law just doesn't have the tools to enable you to divide up ownership in a different way. Equity enables you to divide up ownership any way you want. The reason why the two systems sort of I think devolved, and there's quite a lot of writing on this, is simply because of the education of the people who were occupying offices at the time when within the legal system these things were evolving. The types of people who were the Lord Chancellors, the ecclesiastics, were used to thinking metaphysically and conceptually. And so they just had a better education, really, and the ability to think in different ways that sort of led to this sort of evolution of equity. So if you look at obligations that are recognised in equity, at the one hand you can create trusts. But as we're looking here, there are also other equitable devices you can create. You can create things called powers, where you give somebody a power to do something with an asset. And really what equity has is a spectrum of obligations. The heaviest form of obligation that you can create in equity would be a fixed trust. And then you have a continuum going down of discretionary trusts and then powers, and then you actually have other things, various types of gifts. And from a commercial point of view, you can pick out from this continuum the type of obligation you want with the level of regulation you want that fits the bargaining position of the people who are trying to, when you're negotiating a transaction. So it's like having a whole bunch of flowers, literally, a bunch of flowers, and you can pick whatever you want, whatever suits is going to go well together, and you can bundle them together to create a complex contractual situation. And the equitable obligations enable you as the lawyer to contract to suit the negotiated position that a particular party has taken. So if you look at some of the big financial transactions, like a securitisation, you'll have a whole lot of parties to that transaction, all doing different things. You might have a guarantor who sits there and guarantees some level of debt. You'll normally have some sort of, hedging a relationship because you've got different currencies, or it's operating in a particular way, or you want, you might have some sort of swaps to come in and sort of protect financial positions. So you'll have all these different people with a whole lot of different financial reasons why they're in there. And equitable obligations enable you to describe it in law and give it meaning, literally because you've got this continuum that you can pick out of and put together. So it's the really innovative sort of stuff now, I'd say, that's going on in equity, and really is in some of the financing arrangements that are put in place.
Is there a good simple text on some of it? It's quite interesting.
Oh, it's really interesting. Yeah, there are a number of texts. So any book on corporate finance will go through some of this stuff. There's a woman called Eilish Ferran at Cambridge, there's an English text. There's a more basic Australian one. I think it was Sheila McCracken. So McCracken, I can't remember the other person that writes with her. No, just to, what you want, and because actually, like most things in law, once you understand the words and the concepts, it's not difficult. It's just knowing how various things are put together by people. And when you get into some of the securitization things, that they can get quite complex. And if you contact me, I can give you some names of some other books. But they're sort of under attack a bit since the GFC, because a lot of the structures we used with some of those CDOs, collateralized debt obligations, some trusts we used to formulate those, and of course, post the GFC, some of these devices were heavily criticised and were treated as basically being a part of the reason why the GFC happened. I mean, my own view, and I'm not alone, is that trusts were the structure that was used, and what the real problem was this type of assets that were being put into the trusts. But there's a lot of, amongst securitisation and corporate finance lawyers, I hold annual conferences, and one of the things that is being looked at, is how to use these devices, but ensure that that it's transparent. The nature of the assets that are being put into these things are transparent, so that investors can judge better the quality of something that they might be looking to invest in. Yeah? But in terms of the actual, the trust device, that's just like the mechanics of how you do it. But, and this is why this is such a nice part of practice, the exciting thing is that it's the lawyers who get to create these things. There is a really horrible, it is a bit icky, this statement, but quote that basically says that, what you can do with these devices is as limited as a lawyer's mind. And so the idea is lawyers' minds are unlimited, so we can do anything, we can create anything, yeah. But, and in fact, in commerce and banking, innovation is really important, because actually that gives you your market edge. So it's an unrelenting process in sort of banking and finance law to create new types of products that you can launch onto the market. And these are the tools you can do it with.
Treaty settlements for a while, and when the government makes the settlements with iwi, they have what they call post-settlement governance entities they've got to put in place.
Yes, yeah.
And that was what I worked on.
Right,
I quickly realised that they were actually a parliamentary form of discretionary trust.
Trust, yeah.
And lots and lots of the iwi use them.
Yes. Oh, yeah.
They get a choice. They can do a company, or they can do this trust structure.
Yeah, well, the benefit of the trust structures, but also of a company, is that you can sort of ring fence assets, and then you get the benefits of fiduciary duties and all those things that are recognised as equity as sort of an added, sort of protection to.
The whole concept of fiduciary duty is so much more powerful than a contract.
Yes,
How easy it is to find a loophole in a term of a contract.
Yeah.
But it's a bit difficult to get over fiduciary duty.
Yes, yeah.
Recognised in all sorts of ways, yeah.
Well, that's right, and that's the benefit. That's why when you think about equity, it operates by principle. It's sort of some of it's high principle. So you have, like with fiduciary duties, they are broadly worded. What's good faith? You know, it's a whole lot of things. We can't actually describe it, but what lawyers would normally say is we know it when we see it. We know bad faith when we see it. You know, can't often describe exactly what it is, but so they operate by having these broadly worded, overarching duties that float over everything people do. And normally, you know, you've got a number of fiduciary duties, so one particular action could be a breach of a whole lot of fiduciary duties, and, you know, so what they give you is the ability to attack from a number of different sides. Yeah, and normally, I mean, you know, if you're a litigator and you can allege a breach of fiduciary duty, you do, because it's more powerful. That taint of dishonesty, or, you know, dishonesty and equity is there, and that's powerful. It's a, you know, bargaining tool. Okay, so we tend to use these discretionary trusts in New Zealand, and of those, I'll get to that. There are a number of different types. I mean, the main types are exhaustive and non-exhaustive. That exhaustive just means you've got an obligation as a trustee to distribute the income on the assets annually. We tend not to use those very much. The normal New Zealand family trust would be a non-exhaustive discretionary trust. So under a non-exhaustive discretionary trust, the trustees do not have to distribute anything, and if income is made, then it can be added to capital. Yeah, and there are different devices you can use. There are protective trusts normally used to protect individuals, but you can have trusts that operate as fixed trusts, but then if your beneficiary does something that you don't like, they can revert to a discretionary trust, and what that enables you to do is turn off the tap. Yeah. And in fact, if we look back on New Zealand history, we have some people who were sent out here from England, you know, black sheep in the family. They were often sent out subject to trusts and told, well, the terms of the trust are if you stay out in New Zealand and never come back to the English shores, you'll receive X amount of money per year, but if you come back here, it's gone. I think we call them remittance men. They were called remittance men. So we use them all the time. Okay, so that's our express trusts. Now, the other big pool of trusts we have are these trusts called implied trusts. And what we say about those is that they are not dependent on on a person deciding to put their assets into trust. They basically arise through law. So they're recognised as existing by the courts often. We have two sort of main pools, or some of them will be drafted into statute. So they arise because they're created through statute. But in equity, the two main examples that we have are resulting trusts and constructive trusts. And sometimes they're very similar. Sometimes they're actually identical. We just have two names for the same thing. But resulting trusts are trusts that, the result comes from the Latin word resalere, which basically means to spring back. So often resulting trusts will be brought into play where there's been some problem with the creation, say, of a fixed trust or some, express trust, and for some reason all the things you need for the trust haven't been put in place. And an example of that would be if I was setting up a trust and I was saying you're going to be the trustees, but I never tell you who the beneficiaries are. If I don't tell you who the beneficiaries are, there isn't a trust. But if I've transferred legal title already to you, the law won't treat, you'll hold legal title. So you say, well, are you the absolute owner or are you a trustee? And if you're a trustee, who are you a trustee for? So in that situation where there's that sort of problem, equity brings in a resulting trust, and the trust will operate to bring back the equitable interest to me. So you'll hold on trust for me. We also use resulting trust things where, in equity, where transactions take place, but we don't actually know what is going on. And surprisingly, these happen more often than you think. So somebody might transfer an asset from, to another person, but they never designate exactly what is going on. So they don't say it's a gift, it's a loan, or whatever it is. So the other person will be holding the asset, and then often there's some sort of fight, and there's, and there'll be a dispute as to who owns it. So equity operates something called a presumed resulting trust. So it has presumptions that are set in place which presume certain results depending on the nature of the relationship between the two people. And these have changed over time. So, for example, with a parent, if a parent transfers an asset to a child and doesn't say why they're doing it, doesn't say, here's a gift, honey, have a house, or whatever, and there's a fight as to ownership, the first step that equity would take, because there is a close relationship between the parent to the child, is that they will presume that a gift has been made. And then it would be for the parent to knock that presumption out and say, no, by evidence, no, that's wrong. I never intended a gift. I was always intending a loan, and this is why. Okay. And there are New Zealand cases where people have, things like that have been done to avoid, in the past, to avoid tax, for example. You'd not tell your, transfer ownership of something to your child, and sometimes to avoid other things. You don't want people to know you own things. So these presumptions exist. If on the other hand, so they operate where people have a close relationship. But if you don't have a close relationship, then the presumption goes the other way. So if I came in with $1 million and just handed it over to you, you wouldn't know whether I was giving it to you or lending it to you or saying, or creating a trust. Say, hang on this for me because I'm, just popping out for a bit. So because there's no close relationship between us, the presumption would be that you hold on trust for me, that I didn't intend to give you a gift. And then it would be for you to knock out the presumption and say, nope, Helen came in with that pile of money and said, have this and enjoy your day. That would change. So we use these sort of trusts to work out where ownership is, equitable ownership is. And there's a maxim of equity. Equity abhors a vacuum. And the idea is that the equitable interest, the ability to enjoy the benefits of property, must always be held by a person, or actually have a beneficiary as a company as well. But so you've got to have somebody who holds it, and equitable title is not allowed to just float around with no one attached to it. So resulting trusts will come in to force to say, well, we'll recognise you as the owner first, and then you can fight over. Yeah? Constructive trusts are something that, again, are recognised by courts. Now, there are actually two types of those. There's something called an institutional constructive trust, and they are the type that they use. They're the traditional way we use these sorts of trusts, and they're recognised in England. In Canada, Australia, and New Zealand, we recognise a constructive trust, a different one as well. So we recognised institutional constructive trust, but we also recognise something called a remedial constructive trust. So where a constructive trust is used as a remedy to recognise a particular person as an owner. So there are various situations in law where constructive trusts will arise, and they're normally where some particular person claims absolute ownership of an asset, but for some reason, and normally because there's been some sort of equitable fraud, so something that equity considers to be illegitimate, like undue influence or duress, or those types of things, where something has happened, where the person claiming absolute ownership, equity will say, well, you shouldn't own that property. And so that these traditionally constructive trusts under English law were treated as being only to be recognised in exceptional circumstances. And this is going way back, to 300 or 400 years. Judges, Lord Chancellors said, this is a really powerful device that we recognise in equity, but it should be only ever used in very limited circumstances, because what actually it enables people to do, a court to do, is to take an asset away from one person and give it to another. Say, you're claiming you're absolute owner, but actually I'm not going to treat you as it. I'm going to say that this person owns it. Yeah. And in fact, there are constitutional issues in relation to protecting people's property rights. We're not that good at them in New Zealand, actually. We're much freer. That's what I find, having lived in England for 25 years. In New Zealand, what I find is that the courts here are much more liberal in terms of saying, well, using constructive trusts to recognise somebody else as an owner. And even we have a sort of, anyway. But so in England, they recognise them in very distinct areas. So one of the areas where they use a constructive trust, well, you can use them, is in relation to property ownership where you have an unmarried or uncivil, so there's been no civil union of a couple. Under English law, unlike New Zealand, the matrimonial rules only operate for people who are married or in a civil union or the equivalent. They don't have any statutory rules where people have simply lived together without going through a state-recognised form of marriage, or whatever you want to call it. So if you are in a de facto relationship for a long period of time and you split and and property is in somebody else's name, or it's in both your names but you say that doesn't recognise the proportions it should be in, then your way to challenge that is through, or sometimes you can use resulting trusts, but normally use something called an implied constructive trust of the home. We sometimes still use them in that sort of way, even though we've got rules for various reasons. So, so that would be the situation. You could use a constructive trust. Again, they limit them. They're looking for real contribution. So in England, you would have to show that you had made a financial contribution somehow, so paid the mortgage. They will now recognise payment of other bills if it enables the other couple to pay the mortgage. If you're the one who's not on the legal title, you have to show, normally some sort of financial contribution somehow. Yeah? And the mere fact that you've lived together and raised children together would not give you an interest.
So does the same thing happen on death as well? So that if they weren't married?
There is an act, and I'll have to where you have been dependent on a person and lived together, I think it might be, I can't remember the period of time, but there is an act that will give you a limited ability to have some sort of payments made out to you. But it's a very different approach they take. They take the approach of if you want to share your assets, so they're much more protective. This is where they're much more protective of what people earn for themselves during their lifetime. And they would say, if you want to share your assets, marry. If you do not want to share your assets, cohabit. The trouble with that is that a lot of the population don't know that's the rule. But on the other hand, but what that means is that as an individual, you can protect your assets much more. So the English would say, well, we have to work really hard during our lifetimes to earn stuff, and we should protect as a constitution, they see it more as a constitutional issue, we should protect an individual's rights. So, but New Zealand doesn't take that approach. We're much more liberal with taking stuff away. I mean, I just, so here you have to cohabit for 3 years, and what does cohabit mean? Actually, it can be quite fuzzy, I think. Yeah? So I have a problem with that. I think that's one of the, that is one of the reasons why we have this massive influx of people creating constructive trusts, because the legislation, I would say, this is my own view, the legislation that was put in place to deal with de facto relationships is far too blunt. It's as unfair as the system we had beforehand, I think. Yeah, but so normally, so we have this great influx of, one of the reasons people use discretionary trusts is to get round the relationship property regime. Since the Clayton case, that's been, it's much more problematic. But, and the other problem that we have with our relationship property legislation, I think because it is simply was poorly thought through and put in very quickly, is that you have got this great rise on discretionary trusts to try and take assets out. That ends up being unfair as a social policy, because actually as a country we do need to make sure that when people split up, if they've been together for a long time, particularly if they've got dependents, that there are some fair rules for distribution. You must have that. We don't have that. People avoid it by setting up trusts, and then the courts are basically distorting equitable rules that have operated really well for hundreds of years, because the judges don't have any other tools to do it. So they would say in New Zealand, well, what are we supposed to do? Are we supposed to sit by and see this, because our legislation, there's an unfair result, do we just sit by and do nothing? So I think the New Zealand approach New Zealand judges has taken to say, well, we won't. We won't sit by. We'll use our equitable principles to try and fix things, but in fact what they're doing is distorting them. They're not, they're using them, I think, in some ways that are difficult legally to justify. But, So what we need basically is decent relationship property legislation. And there's a lot of work done. There's a couple of really good, the Scottish Law Commission did an amazing report, and a lot of it was adopted by the English Law Commission because they're still trying to push through, get rights for de facto, couples. When they try and put them forward, the Daily Mail trounces them, stands up for the bastion of marriage. But anyway.
Where does Australia sit in that spectrum?
Australia has been, they've had discretionary trusts that look to get round relationship property, but the Australians, I think it might be Kennan and Spry, if I have the name of the case, they have recognised that interest in discretionary trusts can be treated as a form of relationship property. So they've got round it as well, and their legislation is slightly different. Their legislation, it depends on state to state actually, but I think that some of it focuses not on ownership. So our relationship property looks at what you own and then looks to divide up what you own. The English matrimonial property legislation and the Australian looks at your financial resources. So if you are a beneficiary of a trust and you have been receiving $1 million a year from that trust and you're only a discretionary beneficiary, under those legal systems, they will say, well, you're a person that's, we treat you as having a resource to $1 million a year and relationship property will be divided up on that basis. And often they'll drag trustees into court and say, you've been making a distribution of $1 million a year, we're expecting you to carry on doing that. Are you going to do it? The trustee. So you get into problems. That's fine. Normally if you have a trustee who's an English trustee, they'll nod and say yes. There are arguments that this is a form of judicial blackmail, but or coercion. There's, anyway. But the difficulty over there is that often people will use foreign trusts, and then the English courts would be ordering somebody from the Cayman Islands or the BVI to come in and a trustee and sit down, and the trustees won't do it. So some of those countries have put in legislation to deal with. So nothing's perfect. But our problem, I think, is that we don't look to financial resources. We haven't. In our legislation, we've looked at what you own. And that, and creating a trust carves out what you own, takes out what you own and puts it somewhere else. Yeah. Anyway, I think the Law Commission are looking at this at the moment. Should we just have a 5-minute break? Yeah.